The day after the United States Supreme Court decided Obergefell versus Hodges, same-sex couples all over the United States celebrated the decision by exercising their newfound constitutional right to apply for a marriage license. In a bitterly divided ruling, the court held that the United States Constitution prohibits states from denying same-sex couples the right to marry. James Obergefell and his partner John wanted to get married after John became terminally ill. At the time, they were living in Ohio, a state that banned same-sex marriage. So the couple wed in Maryland, where same-sex marriage was recognized. When John passed away, Ohio upheld its same-sex marriage ban and refused to list James as John's surviving spouse on the death certificate. Obergefell, plus 13 others affected by the same-sex marriage bans, sued the state officials responsible for enforcing the ban. The couples argued that denying them marriage rights violated the 14th Amendment. In each of the separate suits, the district courts agreed with the couples and found that the state's bans violated the 14th Amendment. The Court of Appeals for the Sixth Circuit consolidated the 14 cases and reversed, holding that the Constitution doesn't require a state to recognize same-sex marriages from other states. The Supreme Court granted a consolidated petition for cert. There were two questions before the court. First, are states required under the 14th Amendment to issue marriage licenses to same-sex couples? Second, are states also required to recognize lawful out-of-state marriages of same-sex couples? The court answered both questions in the affirmative and held that same-sex couples have a constitutional right to marry under the 14th Amendment. Further, the court held that the marriage right must be recognized across states. Justice Kennedy, writing for the 5-justice majority, reasoned that the right to marry is a fundamental right protected by the Due Process Clause. For support, Kennedy cited precedent. For example, in the 1967 decision of Loving v. Virginia, the court invalidated a ban on interracial marriages. 11 years later, the court in Zablocki v. Redhill struck down a marriage ban for fathers who were delinquent on child support payments. Additionally, Kennedy noted that judicial precedent had progressed toward greater recognition of rights for same-sex couples. For example, in the 2003 decision of Lawrence v. Texas, the court invalidated laws that criminalized homosexual acts, holding that same-sex couples have an equal right to intimate association. Additionally, Kennedy cited 4 principles and traditions behind the constitutional protection of the right to marry. Each of these traditions applies equally to same-sex and opposite-sex couples. First, the right to choose whether and whom to marry is inherent in individual autonomy. Second, the right protects the intimate relationship between two people. Third, the right protects children and families by giving legal protection to home building and child rearing. And fourth, marriage is the very keystone of the social order and the foundation of the family unit. The deep social importance of marriage is evidenced by the government's provision of numerous benefits to opposite-sex couples, including tax benefits, inheritance rules, evidentiary privileges, and medical decision-making authority. In reaching his conclusion, Kennedy also relied on the Equal Protection Clause of the 14th Amendment. For Kennedy, due process and equal protection were interrelated when it came to the marriage right. He reasoned that the marriage bans denied same-sex couples the same government benefits that opposite-sex couples enjoy. This denial was particularly significant from a constitutional perspective, given the long history of animus towards same-sex relationships. The court reversed the Court of Appeals and held that states must issue marriage licenses to same-sex couples and also must recognize lawful out-of-state marriages between same-sex couples. 4 justices dissented. Chief Justice Roberts began by arguing that the states should be free to say what counts as marriage because the Constitution doesn't define marriage. Roberts further noted that by substituting its own judgment for state legislatures, the majority usurped the right of the people to redefine marriage through the democratic process. Additionally, Roberts warned that if the majority's reasoning is correct, then polygamous relationships should also be entitled to constitutional protection. Justice Alito wrote a separate dissent to argue that because the Constitution is silent on same-sex marriage, the issue is reserved solely for the states. Justice Thomas, in a separate dissent, noted that the majority opinion distorts the doctrine of due process. For Thomas, the Due Process Clause guarantees only the process that is due before someone is deprived of life, liberty, or property. Thomas argued that the Due Process Clause doesn't provide a basis for creating new substantive rights, and that the majority's reading dangerously stretches the constitutional text. Justice Scalia wrote a colorful, bitter dissent. According to Scalia, the majority took on a judicial policymaking role by resorting to pretentious content and, quote, straining to be memorable passages, unquote. For Scalia, the majority opinion was a, quote, threat to American democracy, unquote. Obergefell v. Hodges is the first Supreme Court case to conclude that the constitutional right to marry extends to same-sex couples. The decision was celebrated as a breakthrough ruling that advances equality for same-sex couples, but also criticized as an overstep of judicial authority.